This is LXBN TV, and I'm Colin O'Keefe. The Supreme Court recently announced that it may be revisiting its controversial opinion in Citizens United v. FEC. To discuss the latest developments and what may lie ahead, we bring in Stefan Passantino, head of the political law team at McKenna Long Aldridge in Washington, D.C., and author on their pay-to-play law blog. First off, Stefan, what's the backstory here? Why is the Supreme Court supposedly considering revisiting its decision in Citizens United?
Well, and the key here is not to get too exercised about this yet, because more likely than not, what this is about is the Supreme Court taking a case for the purpose of holding it up and then basically saying we meant what we said before, and Montana, you are part of the union, and you unfortunately are going to have to follow our First Amendment, whether you think that we made the right decision or not. More likely than not, this is the Supreme Court picking this case up for the purpose of batting it right back down.
Yeah, I think that Montana decision has been very popular, but it always struck me as how can they do that? But yeah, I mean, you mentioned it already, but what do you think will happen? Is it going to get just smited right back down as soon as it got picked right back up?
Yeah, I do think that. And I think the thing that made this interesting was the fact that in the process of taking the case and entering the stay against the enforcement, you had two Supreme Court justices, Ginsburg and Breyer, saying we would love to be able to use this opportunity to undo Citizens United. I have no doubt that that's true, but that signals absolutely nothing about what the majority of this Supreme Court is going to do. And you had asked a little about what the backstory was. It is somewhat interesting in how this arose, in that Montana, like many other states, had its own state rule that said corporations can't use their money to advocate for and against candidates. Well, the Supreme Court in Citizens United expressly said, no, the First Amendment says they do have that right to do that. What the Montana Supreme Court did, and it's actually a fun read if you look at the case itself, but what the Supreme Court in Montana said is, well, really all that the United States Supreme Court said is, we don't find a compelling state interest here in preserving our elections or anything, so we, the Supreme Court, are not going to overturn this First Amendment issue. The Montana Supreme Court said, well, Supreme Court of the United States, you looked at it and you don't find a compelling state interest, but we in Montana do. And they talk a fair amount about a number of different issues about what the Montana compelling interest is, about you can have PACs, about they literally walk through 1902 corruption in Montana and these companies that were apparently not very good actors in Montana in 1902 as the basis for which the Montana Supreme Court says, well, while the U.S. Supreme Court doesn't find a compelling state interest, we do, and therefore we're going to go ahead and uphold Montana's prohibition. It becomes very clear when you read it what they're most interested in is the fact that judges are elected in Montana, and they are most interested in making sure that this money doesn't go to defeat incumbent judges. That's actually kind of an interesting read. Where, of course, it's exactly wrong, however, is that while the Supreme Court, in ruling that the First Amendment analysis trumps, did not find a compelling state interest, that doesn't open up the door to any other court saying, well, we do find a compelling state interest, so we're going to impose our First Amendment analysis above the United States Supreme Court. Doesn't work that way. I don't expect it's going to go very long. I put on my blog an over-under of how many words it's going to take the U.S. Supreme Court to reverse and remand consistent with Citizens United. I've been getting an equal number of bids and under bids, so I think I've set the line properly at 25. But we'll see. That's my guess.
Yeah, it's going to be interesting to watch. It doesn't look like this has as much momentum as I think some of the stories would have led you to believe. But, with Montana, do you think this is going to be the last of challenges to Citizens United? And do you see the court, ever truly revisiting their opinion there?
Well, this is, without a doubt, not the last of the challenges to Citizens United. Citizens United will be challenged in every form, clearly in the judicial form. Clearly, we've seen it through the legislative, where the Disclose Act is coming up again. Clearly, we're seeing it through the executive branch. Clearly, we're seeing through the Securities and Exchange Commission, the IRS, and a number. Challenges are coming from everywhere.
Yeah.
whether this Supreme Court, these justices, overturn their own decision and Justice Roberts lets that happen, I don't personally think that's going to happen. I don't think, unless you have a different makeup of the Supreme Court, that the core fundamental First Amendment analysis that supports it is going to get overturned. There might be avenues to effectively limit its impact in requiring more disclosure, which the Supreme Court does not apparently have too much trouble with. It's more the First Amendment side.
Yeah.
That's where the challenge is really going to come from. I don't think this Supreme Court is going to overturn its decision in Citizens United.
Yeah, it's a very controversial opinion and one that's going to get hit from all angles, but it doesn't look like this here is going to be the development or the case that's going to make the court go back on it. So it's going to be interesting to watch going forward, but it doesn't look like this is going to be where it's going to happen.
So your guess on the over-under of 25 words, more or less, to resolve this Montana?
I'll guess over for right now, and we'll see what happens when it comes out. I'll have to come back and check, but I'm going to guess over for right now. Maybe it'll get upwards towards 50, but we'll see. Once again, that was Stefan Passantino of McKenna Long Aldridge. For more on the story, be sure to visit their publication. It's the Pay to Play Law blog. Be sure to check that out, and also we have more on the story at lxbn.lexblog.com.